Good day, I'm Jake March Rañada from BSHM 3A. And for today, I will be tackle the chapter 3, which is the Law on Obligations and Contracts. What are the learning objectives? First, identify the different kinds of obligations and contracts. Second, the ways of extinguishing an obligation. Third, enumerate possible application of contracts in the tourism, travel, and hospitality industry. A person desiring to engage in a business in the tourism, travel, and hospitality industry will meet certain obligations. Agreements arising from contracts will have to be made, and potential breach from these agreements will be encountered. Therefore, there is a need to study the fundamental principles involving law on obligation and contracts. In Article number 1156, an obligation is a juridical necessity to give, to do, or not to do. An obligation is a legal duty, however created, the violation of which may become the basis of an action of law. Every obligation has four definite elements, without which no obligation can exist, to wit, first, an active subject, also known as the oblige or creditor, who has the power to demand the prestation. Second, a passive subject, also known as a debitor or who is bound to perform the prestation. Third, an object or the prestation, which is an object or undertaking to give, to do, or not to do. And lastly, the juridical or legal tie, the vinculum which binds the contracting parties. The juridical tie or vinculum is based on the sources of obligation arising from either the law or contract. It is important to identify the prestation in a certain obligation. Once the prestation is identified, you can determine who the passive subject is, whom the active subject can demand fulfillment of the obligation. The following are the obligations of the passive subject in first, obligations to give a determinate thing. These are first, to deliver the thing which he has obligated himself to give. Second, to take care of the thing with the proper diligence of a good father of a family. Third, to deliver all its accessories and accessions. And lastly, to pay damages in case of breach of obligation. Obligations to do. These are first, if the debtor fails to do what he is obliged to do, it will be done at his expense. Second, if the work is done in contravention of the tenor of the obligation, it will be redone at debtor's expense. And lastly, if the work is poorly done, it will be redone at debtor's expense. The sources of liability of a party in an obligation are as follows. First, fraud. The fraud is incidental fraud, or also called dolo incidente, which is fraud incident to the performance of an obligation. In fraud, there is an intent to evade the normal fulfillment of the obligation and to cause damage. Second, negligence. The negligence referred here in the case of contracts, which is common carrier, is culpa contractual, the lack of diligence or carelessness. Negligence consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, or the time and the place. In Article number 1157, obligations arise from first, law, second, contracts, third, quasi-contracts, fourth, acts of omissions punishable by law, and lastly, the quasi-delicts. There are only two sources of obligation, namely first, law, and second, contracts. Because obligations arising from quasi-contracts, crimes, Number 4, Article number 1157, Civil Code of the Philippines. And quasi-delicts are really imposed by law. A contract is a meeting of the minds between two persons whereby one binds himself with respect to the other, to give something or to render some service. Quasi-contract refers to a lawful, voluntary, and unilateral act based on the maxim that one should unjustly enrich himself at the expense of another. The two common forms of quasi-contracts are, first, solution indemnity, which is payment by mistake, and second, negotiatorium gesture, which takes place when a person without the consent of the owner assumes the management of abandoned business. Civil obligations arising from criminal offenses are governed first by the provision of the revised penal code, like restitution, reparation of the damage caused, indemnification of consensual damages, and second, by the provisions of the Civil Code on damages, like moral, exemplary, and nominal damages. Quasi-delict, also called culpa aquiliana, is any act or omission which causes damage to another, there being fault or negligence, and there being no pre-existing contractual relation between the parties. Classification of obligations. Primary classification of obligation under the Civil Code. First, pure and conditional obligations. Second, obligations with a period. Third, alternative and facultative obligations. Fourth, joint and solidary obligations. Fifth, divisible and indivisible obligations. And lastly, obligations with a penal clause. Secondary classification of obligation under the Civil Code. First, unilateral and bilateral obligations. Second, real and personal obligations. Third, civil and natural obligations. And lastly, legal, conventional, and penal obligations. Modes of extinguishing obligations. In Article number 1231, obligations are extinguished. First, by payment or performance. Second, by the loss of the thing due. Third, by the condonation or remission of the debt. Fourth, by the confusion or merger of the rights of the creditor and debtor. Fifth, by compensation. And lastly, by novation. Other causes of extinguishment of obligation, such as annulment, recession, fulfillment of a resolutory condition, and prescription, are governed elsewhere in this code. In Article number 1305, a contract is a meeting of minds between two persons whereby one binds himself, with respect to the other, to give something or to render some service. The essential elements of a contract are as follows. First, consent, which is manifested by the meeting of the minds of the offer and the acceptance upon the thing and the cause which are to constitute the contract. The offer must be certain and the acceptance absolute. Second, object certain, which is the subject matter of the contract. And lastly, cost of the obligation which is established. A contract of adhesion is defined as one in which almost all the provisions have been drafted only by one party, Usually, a corporation or insurance company, the only participation of the other party is signing off his signature or his adhesion. Some writers believe that such contract suppresses the will of one of the contracting parties, hence, not a true contract. However, this is not always juridically true. Normally, the party who adheres to it is in reality free to reject entirely. If he adheres, then he gives his consent. Characteristics of a contract. First, mutuality of contracts. Its validity and performance cannot be left to the will of only one of the parties. Second, autonomy of contracts. Parties are free to stipulate terms and provisions in a contract, as long as these terms and provisions are not contrary to law, morals, good customs, public order, and public policy. Third, relativity of contracts. Contracts are binding only upon the parties and their successors in interest, exception, stipulation in favor of a third person. Fourth, consensuality of a contracts. Contracts are perfected by mere consent, and no form is prescribed by law for their validity. And lastly, obligatory force of contracts. By the obligatory force of contracts, it constitutes the law as between the parties who are compelled to perform under the threat of being sued in the courts of law. Classification of contracts. First classification of contracts is according to their relation to other contracts. First, preparatory, or those which have for their object the establishment of a condition in law which is necessary as a preliminary step towards the celebration of another subsequent contracts. Example, partnership, agency, common carrier, and insurance. Second, principal, or those which can subsist independently from their other contracts and whose purpose can be fulfilled by themselves. Examples, sale, lease, common carrier, and insurance. Third, accessory, or those which can exist only as a consequence of or in relation with another prior contract. Examples, pledge or mortgage. Second classification of contract is according to their perfection. Consensual, or those which are perfected by the mere agreement of the parties. Examples, sale and lease. Real, or those which require not only the consent of the parties for their perfection, but also the delivery of the object by one party to the other. Example, comodatum, deposit, and pledge. Third characteristic or classification of contract is according to their form. Common or informal, those which require no particular form. Example, loan. Special or formal, or those which require no particular form. Example, donation, shuttle, and mortgage. Fourth classification of contract is according to their purpose. Transfer of ownership. Example, sale. Convenience of use. Example, commoditum. Rendition of services. Example, agency, lease of services, and labor. The fifth classification of contracts is according to their subject matter. Things, examples, sale, deposit, and pledge. Second, services, example, agency, lease of services, and labor. The sixth classification of contract is according to the nature of the vinculum which they produce. Unilateral, or those which give rise to an obligation for only one of the parties. Example, comodatum, gratuitous deposit. Bilateral, or those which give rise to reciprocal obligation for both parties. Examples, sale and lease. The seventh classification of contract is according to their cause. One ruse, or those in which each of the parties aspires to procure for himself a benefit through the giving of an equivalent or compensation. Examples, sale, insurance, and common carrier. Gratuitous, or those in which one of the parties proposes to give to the other half or benefit without any equivalent or compensation. Example, comodatum. The eighth classification of contract is according to the risk involved. Commutative, or those where each of the parties acquires equivalent of his prestation and such equivalent is pecuniarily appreciable and already determined from the moment of the celebration of the contract. Aleatory, or those where each of the parties has to his account the acquisition of an equivalent of his prestation, but such equivalent, although pecuniarily appreciable, is not yet determined at the moment of the celebration of the contract, since it depends upon the happening of an uncertain event, thus charging the parties with the risk of loss or gain. Example, insurance. The last classification of contract is according to their names or norms regulating them. First, nominate, or those which have their own individuality and are regulated by special provisions of law. Examples, sale, lease, common carrier, insurance, deposits, and lastly, agency. Second, innominate, or those which lack the individuality and are not regulated by special provisions of law. In the Roman law, the innominate contracts were classified into four groups: duotes, or I give and you give; duot fascias, which is I give and you do; fascio or you fascias, or I do and you do; and lastly, the fascio ot des, or which means I do and you do.